Hello everyone, from the Parliamentary Working Group, I'm DVJ, a land law professional. I honor to be able to participate in these important conversations about whether our current law legislation system truly meet the needs of a 21st century society. There is a society that values accessibility, efficiency, and transparency in land ownership. The land management system in England and Wales is divided into an unregistered land regime and a registered land regime. Unregistered land relies on a series of paper deeds to prove ownership, which makes land transaction time-consuming and full of uncertainty. In contrast, registered land use a centralized digital register maintained by the UK Land Registry to record ownership and certain rights, providing greater clarity, speed, and security. The turning point came with the enactment of the Land Legislation Act 2002, which was designed to simplify the title transfer process and modernize land law. The Act introduced clearer title transfer rules, increased digitalizations, and committed to making the register a comprehensive record of land ownership. Central to this term, too, Miller principle, which aims to ensure that the register reflects the true state of legal rights to land like a miner. Before 1925, land law was fragmented and unpredictable. Reform of the Law of Property Act 1925 and its related regulations introduced a more sophisticated structure, and in 2002, the Act further encouraged electronic registration, reducing hidden risks in real estate transactions. However, some changes remain. About 10% of land remains unregistered, often because the land is held for a long time by institutions such as universities of the British Crown. In addition, overriding interests, there is rights that do not appear on the register may still buy buyers trust weakening transparencies and legal certainty. Now I will explore the Miller principle and how it works in theory and practice and purpose reforms to improve land law in the 21st century. What is Miller principle? Now imagine a miner. What you see should reflect reality. The Miller principle is a fundamental concept of the land legislation system. It holds that the land legislature should accurately reflect the ownership and rights affecting the land. In other words, what you see on the register is what you get. The idea is that anyone involved in a land transaction, such as purchases or mortgages, can rely on the register as a complete and up-to-date account of or relevant legal rights. This is intended to replace the uncertain and cumbersome paperwork of the registered land system, where buyers have to trace and review the chain of ownership through the title deeds. The LRA 2002 further established the finality of a register, in particular section 15.8, which provide that once a person is registered as an owner, he is deemed to have legal title even if the registration process is deductive. However, the Miller principle is only one of the three fundamental principles of the registered land system. The other two principles include the caution principle and the insurance principle. The caution principles hides certain equitable rights behind the trust. The law provides that these rights do not appear on the register and buyer do not need to worry because they are hidden behind a certain later than deduced trust arrangements such as family interest being filled out on the register. For example, if A and B hold a trust for C lands, C land will not appear on the register, but his interests will be protected by mechanisms such as the trust of land and appointment of trustees Act 1996. The insurance principle ensures that when someone suffers a loss due to an incorrect or incomplete register, such as being mistakenly delete or losing land due to fraud, they are compensated or compensate. The compensation scheme is set out in Schedule 8 of the LRA 2002, ensuring that the system remains fair even when errors are made. In theory, these three principles work together to make the legislative land system easy to understand, emphasis, and safe. The Miller principle provides transparency and clarity. The consent principle prevents private information overload, and the insurance principle provides a safety net. In simple terms, these three principles together aim to simplify the title transfer process, protect buyers, and enhance trust to land transactions. However, the minor principle does not always work perfectly in practice. For example, certain purity interests, such as the rights of extra occupants, may exist without legislations, thereby undermining the minor principle. Trust, while the principles remains central to the legislative land system, its application is far more complex than its metaphor would suggest. Now, here is the big question. Is the minor principle working in practice? The answer is no, really. While the minor principle is a core idea of the land legislation system, its practical application is limited and imperfect. In theory, it promises clarity, meaning that the legislature accurately reflects ownership and rights. However, in practice, numerous exceptions and complications mean that the legislature may not always give a full picture, reducing its liability. A major problem is the existence of overriding interests. These are rights that by a purchasers, even though they do not appear on the register, such as the equitable interest of an extra occupier, a short lease of less than 7 years, or a statutory easement. This undermines the idea of the integrity of the land register. For example, a purchaser may rely on the register to purchase a property only to discover that someone is already living there with a protected interest. This problem was highlighted in King Snow Finance and Title on 1986. In this case, the mortgagee was unaware of his wife's occupations and was given priority even though her equitable interest had not been registered. Dai Qing may argue that the minor principle is inherently flawed because the law protects hidden, unregistered rights in the name of fairness. However, this comes at the expenses of legal settling for buyers. Jeffenbergen argued that the minor principle has been oversold. He criticized the realism of a perfect minor, pointing to practical issues such as trust law, possessing rights, and historical injustice that prevent full legislations of an interest. On the other hand, Cooper and Lees announces that flaws but argue that the electrification and compensation mechanisms under the LRA 2002, particularly Schedule 4, provide a remedial framework to correct errors. However, as shown in Swift First Limited and Surf Land Register on 2015, the courts has been arguing over whether rectification of the register creates or reflects property rights. This conceptual uncertainty limits the effectiveness of mining. Furthermore, 10% of land in England and Wales remain unregistered. This means that the register does not yet reflect the true national land ownership situation, which weakens the effectiveness of mining from a systemic perspective. So, while the minor principle remains a useful theoretical goals, it is not fully supported in practice. Hidden rights, overriding interests, and conceptual confusion all create what Professor Martin Dixon called cracks in the mirror, meaning you could imagine buying a house only to discover that someone else had legal rights on occupying it without your knowledge. So these interests are essential to the minor principle. This suggests that if the legislature is to be a fully reliable tool, it needs to be reformed. How can we restore the minor credibility and improve the LRA 2002 to meet our modern needs? Although the LRA 2002 has significantly improved the efficiency and security of land transaction, various constraints still hidden its goal of establishing a transparent and complex system in order to enhance the reliability of a system and uphold the minor principle in practice. Several target reforms are necessary. First, the state needs to speed up the legislation of unregistered land. About 10% of land in England and Wales is not registered. And this land is often held by institutions such as university, colors, or the crown. This prevents the overall functioning of the system. One possible solution is to make legislations of ownership mandatory for all landowners within a fixed period, such as 5 years. Expecting the coverage of the legislature is essential to establishing a comprehensive national record of ownership. Such reforms will help improve accessibility and reduce legal uncertainty in real estate transactions. Second, the state needs to clarify and narrow the scope of lighting interests. The concern of auto-lighting interests is one of the main reasons why the minor principles has failed in practice. Purchasers may face unforeseen claims from occupiers or beneficiaries whose rights are not acceptable on the register. While periodic interests protect vulnerable occupiers, the list in Schedule 3 of the LRA 2002 could be reformed to require more proactive disclosures or mandatory legislations of certain equitable rights, particularly when they arise from trusts as King's norm, finance, and legal norm. Narrowing the scope would better balance fairness and transparency. Third, the state needs to statutory definitions and reclassification of the rights to legislify. The rights to legislify the legislature under Schedule 4 remains conceptually unclear. As Cooper and Lees note, the courts are inconsistent in whether to treat a right as an exclusive right or merely a discretionary power. The legal ambiguity affects both plaintiffs and legislative owner. Legislative reform should clearly define the rights to legislify as a condition title detailing when it applies its scope and the impact of third-party purchasers. This would reduce litigation uncertainty and enhance the public understanding of their rights. 4. The state needs to make the legislature more accessible and user-friendly. Land legislation are often difficult for non-lawyers to understand, which limits public participation and transparency. Reforms should include the development of a digital, open interface and visualize ownership boundaries, property rights, and possession and comprehensions. This will help first-time buyers, house activists, and ordinary citizens better understand the issues they face, in line with modern expectations for accessibility and governance openness. This reform will strengthen the minor principle, reduce disputes, and enhance public trust in the system. They will also help create more inclusive, efficient, and transparent land markets consistent with 21st century housing, planning, and economic development policy goals. In summary, this presentation explored three key areas of land legislation in England and Wales. First, I explained the minor principle along with the second principle and insurance principle, which are fundamental concepts designed to simplify and safeguard land ownership. Second, I critically assess how the minor principles works in practice, revealing that preferential interest, conceptual confusion, and gaps in legislations undermine its effectiveness. Third, I propose practical and forward-looking reform, including expanding the scope of legislations, limiting preferences, interest, clarifying rectifications, rights, and improving accessibility of the legislature. Also, the LRA 2002 marked an important step forward. The legal framework still needs to be improved to meet modern expectations of transparency, accessibility, and fairness. The legislature should not only serve lawyers, but also empower the public, owners, and communities. I hope the working group will adopt these recommendations and build a more reliable and exclusive land system for future generations. If we want a system that truly embodies accessibility, efficiency, and transparency, then we must police the minor. So let's finish the legislation's work and build a system that the public can trust. Thank you for listening.